Welcome to Risk Matters, the insurance podcast brought to you by DWF and your global guide to the latest trends and issues in the insurance and reinsurance industry. Join us as we explore topical issues, emerging technologies, and the innovative strategies that are shaping the global future of insurance.
Welcome to Risk Matters, the insurance podcast from DWF. Today we'll be talking about the North American opioid crisis and some of the issues that this has generated for the insurance industry. My name is John Groom. I'm a partner in DWF's global risk team. And today I'm joined by fellow partner Anthony Woodhouse. Hello, Anthony.
Hi.
And very pleased to have with us two guests. Nathan Barnett, who's Casualty Claims Manager for Swiss Re Corporate Solutions Services Limited, and Kent Wilson, US Attorney from Wilson & Ryan, a firm affiliated to Bates Carey in Chicago.
Right.
Welcome, Kent.
Thank you.
Kent and I have been working together on US risks for approaching 20 years. In fact, I think the 20th anniversary is just upon us.
Right.
I'm going to start off by reading a very short extract from the opening words in the judgment in Harrington and Purdue, which was handed down by the US Supreme Court in June this year. And it sets the scene, really, from what we're going to be talking about. And this is how it reads. Between 1999 and 2019, approximately 247,000 people in the United States died from prescription opioid overdoses. Purdue Pharma sits at the center of that crisis. Owned and controlled by the Sackler family, Purdue began marketing OxyContin, an opioid prescription pain reliever in the mid-1990s. After Purdue earned billions of dollars in sales on the drug, in 2007 one of its affiliates pleaded guilty to a federal felony of misbranding OxyContin as a less addictive, less abusable alternative to other pain medications. Thousands of lawsuits followed. Fearful that the litigation would eventually impact upon them directly, the Sacklers initiated a milking program, withdrawing from Purdue approximately $11 billion, roughly 75% of the firm's total assets, and this was over the next decade. But that's now. Let's turn the clock back to the very beginning. Kent, tell us about the history. How did this all kick off?
In 1996, the Purdue companies instituted a new drug application to the FDA for OxyContin, which essentially was and is a time-release oxycodone Schedule II opioid. Initially designed and marketed for cancer pain, the Sackler family, who completely owned all of the Purdue entities, started expanding the so-called use of the drug and made the fraudulent claim that it was half as addictive as morphine, when in fact it was more than twice addictive as morphine. Within a matter of 1 or 2 years, death cases started to be reported to the FDA as adverse event charges. In the fullness of time, in 2001, the opioid litigation was in full swing, and Purdue declared under its insurances an integrated occurrence, basically saying we want insurance money for all of the liabilities that we're incurring. Notwithstanding the fact that Purdue was aware of the adverse events and was aware that it was marketing the drug off-label, meaning outside the purview of FDA rules, it nevertheless continued selling the drug, promoting it in ever-increasing amounts. The initial dosage of oxycodone and OxyContin was 10 milligrams, but what they realized was they could get their market to increase volumes by increasing the dosages. So pills started being made for 40 milligrams, 60 milligrams, 100 milligrams, each one more expensive to sell and to buy, and similarly, more addictive.
I wonder if I could bring Nathan at that point just to see when it first registered from an insurance point of view. Mm-hmm. Because we're going back now to 2001 we were talking about. And Nathan, did it come to your attention at that time?
Yeah, well, actually, a couple of years before that, we had started to see the early notices. So I think it was 99
Yeah.
individual claims that they had started to notify. As Ken said, it was in 2001 that they batched it and gave notice of an integrated occurrence of the issue. And then for us, that was that was the beginning of what was a decade of multi-district litigation, class actions, hundreds and hundreds of individual lawsuits. But at that time, as Kent's saying, it was a drug that we were told was marketed ultimately for cancer patients and terminally ill, serious injuries. We were unaware, right, that they were flooding the market with it.
No.
And we very much believed all through that period that they were the victims in this, right? Purdue were, because we were told that the people that were abusing the drug were criminals and drug addicts already, who were crushing this tablet that was supposed to dissolve over 12 hours in the system, crushing it for instant highs. And that's the US phrase of drinking the Kool-Aid. We truly believe that this was a good drug being used by bad people and abused for many years. Right? But that was the beginning of obviously we didn't know then what we know now about the flooding the market and creating the addiction. But
yeah, and so Ken, as the years passed by, I think it was around about 2009 that they pleaded guilty to these offences. Could you tell us a little bit about that?
Yeah, the FDA came after Purdue, starting in around 2005, doing an investigation, and it was in 2007 that Purdue pled guilty to a number of federal charges for promoting the drug outside the bounds of FDA rules. And they promised that they would be good boys and not do it again. That having been said, that promise went out the window, and they went back to their ways of flooding the market with even more OxyContin. In 2011, they decided that the primary problem with the drug was that if you crushed the drug, you eliminated the time element and you sped up the addiction. So they invented a crush-proof OxyContin that they claimed was now good and was now safe, which in fact it was not. And they continued selling OxyContin in massive amounts. Approximately 2018, they came to the realization that they were in deep trouble. The litigation had taken a turn. They had already spent over $700 million in defense costs to defend the litigation, and they were now wanting to protect. The Sackler family, wanted to protect their fortune. As of around 2018, 2019, the Sackler family was reputed to be worth about $17 billion. We don't know the exact number because the Purdue entities were all privately held companies. There was about 26 of them. But the Sacklers were making staggering amounts of money. And in fact, we have seen documents where they were having quarterly family meetings where they were distributing to family members $400 million a quarter for a number of years.
This is the milking program.
This is the
Supreme Court.
Exactly. This is the milking program. Upon the filing of the Chapter 11 reorganization in September of 2019, the Purdue entities had already formulated a potential settlement plan, which would in fact be the plan of reorganization. That settlement plan called for all of the assets of all 20, I believe it's 26 of the Purdue companies, to be transferred to the trustee in bankruptcy with a value that Purdue claimed to be approximately $10 billion. In addition to the transfer of assets, the Sacklers agreed to pony up about $3 billion of their own money, which would reduce their fortune from $17 billion to $14 billion. For the following year or two, the creditors, the unsecured creditors, the secured creditors, and the various and sundry plaintiffs who had been injured spent their time doing an analysis of what was the actual value of the Purdue companies. Purdue said they're all worth about $10 billion. The unsecured creditors committee and the creditors committee said not so much. And the probable likelihood is that those companies are worth about $2 billion. That having been said, in the fullness of time, the Purdue entities, which did not include the Sacklers were not parties to the bankruptcy, filed a motion to the bankruptcy court seeking approval of, quote, the plan. There were objectors to the plan, but they were in a minority, and the bankruptcy court overruled the objections filed and approved the plan. The objectors then proceeded to file an appeal of the approval of the plan to the next higher court, which is the U.S. District Court in New York City. The claim by the objectors were that the Sacklers would receive relief from future lawsuits in return for their $3 billion contribution to the plan, notwithstanding the fact that they were not parties to the bankruptcy. The question, therefore, before the court was, do the Sacklers, who are not parties to the bankruptcy proceeding and thereby not arguably protected by the Bankruptcy Act, nevertheless entitled to relief for future claims? The district court said, no, they're not, which essentially blew up the plan. Purdue then took an appeal of that ruling to the Second Circuit Court of Appeals. The Second Circuit reversed the district court and said, no, the Sacklers can get relief, notwithstanding the fact that they're not parties to the bankruptcy court. That case then went on appeal to the United States Supreme Court, and the Supreme Court granted certiorari such that the appeal actually the appellant in this case was Mr. Harrington, who is the U.S. trustee for Region 3 and one of the parties to the bankruptcy plan. Under the Supreme Court case, which was argued on December 4th of 2023 and decided in June of this year, the Supreme Court sided with the district court and said, the Sacklers do not get relief under the Bankruptcy Act absent complete consensus by all of the parties to the plan. They are a third party, and without that consensus, they do not have any rights under the Bankruptcy Act. As a result of that ruling in June, which cemented the fact that the proposed plan, by which, by the way, the Sacklers had agreed to amend their contribution from $3 billion to $4.3 billion, $3 billion to $4.3 billion. Nevertheless, the court said, well, we can't go through this process again forever. So the court has assigned a mediator between the various creditor committees and Purdue and the Sacklers to see if a plan that meets the strictures of the Supreme Court case can be assembled. That mediation is going on right now. In the meantime, the Unsecured Creditors Committee has recently filed a motion before the bankruptcy court seeking leave to sue the Sacklers for their having looted the company. That motion is scheduled for hearing on October 27th of this month. The question for the court is not whether the Sacklers can be sued. The question is whether or not the Unsecured Creditors Committee has standing to sue, i.e., are they an entity that can claim rights against the Sacklers? We'll find out in a couple of weeks.
Going back to the Supreme Court, it was a very close run thing, wasn't it? It was 5-4.
5-4 decision, which was very surprising, certainly to me and to most everyone. Every lawyer that I talked to over the months and years and reviewing the briefs, we were all convinced that this was going to be probably either a 9-0 or a 8-1 decision in favor of not allowing the Sacklers to benefit from their criminal acts. The fact that it was a 5-4 decision was pretty surprising.
Yeah. Now, while all that's been going on, the insurers became involved along the way because suddenly they found themselves drawn into the bankruptcy court in New York. Nathan, you'll recall this very clearly.
Yeah, so I mean, ultimately we had resolved what were the bodily injury claims, which is over that sort of going back to 20 years now, and those were people that had actually been addicted to it, and we had paid out those bodily injury claims almost sort of one whole policy, and there were to the to the limit almost, because there was Canadian class, which I think was going through around 2015, was it? 2015. And we thought that was the end of the story, right? But then obviously Purdue brought us back in, right?
And this was irrespective of whether insurance companies had arbitration clauses.
Mm-hmm.
They were brought into the bankruptcy court, Southern District of New York, and that's when the fun began.
What happened was in January of 2021, after most of the accounting had been completed in terms of determining the value of the Purdue companies, the Unsecured Creditors Committee in Purdue decided it's time to see if we can't bolster the assets via going after the insurances. So in January of 2021, they filed a declaratory judgment suit in the bankruptcy court against all of the insurers in the 2001 Tower of Insurance, which were all Bermudian forms with resolution clauses requiring London arbitration with the law of New York to apply. But they also sued their post-2001 domestic insurers. This is kind of an interesting development because the domestic insurers, on the heels of the integrated occurrence that was filed in 2001, put products liability exclusions into their policies.
Wise move.
And so they believed that they were protected. As it turns out, Purdue came up with the idea that we can sue the domestic insurers notwithstanding the products liability exclusion, because part of the liability of Purdue is having the fact of their promoting opioids, period, meant that even if a victim died from a heroin overdose, that heroin overdose was caused by Purdue's promotion of OxyContin. And thereby, since heroin is not a product manufactured by Purdue, therefore they could sue Purdue and get around the products liability exclusion. The upshot of that lawsuit, which was the 2001 Tower, which included all of the we call them the arbitration insurers, filed motions to dismiss in the bankruptcy court on two grounds. First was that the court did not have jurisdiction over them because they were foreign insurers. And secondly, that the Federal Arbitration Act prohibited the Unsecured Creditors Committee and Purdue to going after the insurers because of the arbitration clause. The court decided not to address at all the jurisdiction question, but nevertheless did address the arbitration clauses and stayed the actions against the arbitration insurers until such time as the litigation against the domestic insurers had completed. So effectively from 2021 to now, there has been litigation ongoing against the domestic insurers. However, once the district court ruled that the Sacklers could not get a benefit out of the plan as constituted, the plan was blown up, and the domestic insurers basically said, we can't go forward with litigation when we don't know what the plan is. So the litigation against the domestic insurers has been stayed, as has been the case against the foreign arbitration insurers, and that's where it stands right now. The upshot is that the domestic insurance declaratory judgment action will recommence once the mediation over the plan is concluded and a plan and a non-appealable plan is in place. We have no idea when that's going to be. The bottom line here is that, assume for the sake of argument that a deal can be cut by the end of this year. It would probably take until the middle of 2025 for the plan to be approved and finalized with no objections, at which point the domestic insurance litigation would recommence and probably take another year or two. And once that concluded, then in theory, Purdue and the other entities could go after the foreign insurers on the arbitration clauses.
Yeah. And Anthony, it's not just about Purdue.
No, absolutely not. I mean, that's one of the key features here is that because of the breadth of this problem, and the number of different complainants and complaints being made, the likely defendants are huge. I mean, there's a real range. So as an example, there was an MDL litigation in Cleveland that had brand name opioid manufacturers, so people like Purdue, Johnson & Johnson. They had generic opioid manufacturers, people like Mallinckrodt and Teva.
Yeah.
They had opioid distributors, McKesson, Cardinal Health, those sort of defendants, AmerisourceBergen, the big one. They had pharmacy benefits managers, people like Caremark and Express Scripts, who decided how much could be prescribed in hospitals. And they had pharmacies as well, high street pharmacies, CVS, people like that.
Rite Aid.
And also, I mean, it's interesting. I read an article yesterday where other people are being brought into this too. So even there's a well-known firm of strategy consultants who paid many hundreds of millions of dollars because they advised Purdue on their strategy for selling oxycodone.
Yeah, and I think they attended certain board meetings as well where those non-family members were excluded when certain advice was given. Yeah, but we need to look at who are making the claims, because when it all started off, Nathan, it was just individuals who'd suffered personal injury, and it looked fairly straightforward. But it's developed, and what we have now are these claims that have been coming in now for 5-6 years from cities, from
municipalities, states,
so on.
Absolutely.
And the legal theories that are being argued by these underlying claimants, Ken, seem to revolve very largely around public nuisance.
And in fact, that is the primary claim. And the remedy in public nuisance is abatement. And that raises an enormous coverage question, because abatement is not a remedy that addresses past harm. It's a remedy that addresses the elimination of potential future harm, which is not what the insurance policies are designed for. It's a very interesting situation. What makes it even more complex is there's no such thing as federal public nuisance law, notwithstanding the fact these cases are venued in a federal courthouse in Cleveland, the MDL for the opioids. Public nuisance is state law and varies state to state.
Yeah.
In fact, there has been a litigation in Oklahoma, for example, in which the Supreme Court of Oklahoma said public nuisance does not apply. Does not apply to the opioid. These are products liability cases.
Yes.
They're not public nuisance cases. Similar litigation took place in Rhode Island with regard to the lead paint litigation. And again, the problem for the plaintiff lawyers is, whether it's an opioid or whether it's lead paint, is who made it. To have a products liability case, you have to be able to identify the person who made the product. But because the opioids are fungible, as is lead paint, there's no way to identify the bad guys. And as a result, products liability claims failed across the board, which is why the plaintiff bar came up with this public nuisance theory. And the first time I saw it being used was in Rhode Island in the lead paint cases. And following a huge verdict against a Dutch Boy and some of the other major paint manufacturers, the Supreme Court of Rhode Island declared that public nuisance is an inappropriate remedy for what are essentially products liability cases.
So now we're coming into a very interesting area as far as the insurance market is concerned, because these policies that have been issued, Anthony, you might like to say a little more about this, whether Bermuda form, whether they're domestic policies, policies issued out of the London market, never envisaged that they would be covering claims for public nuisance, and certainly not for abatement.
I think that's absolutely right, John. I mean, the words in the insuring clause are interesting. It's about liability being imposed on account of bodily injury or personal injury. And so the question is that broad enough to cover these claims? They're certainly not traditional claims. Your traditional claim is a person injured or a batch of people injured sue for their personal injury, and that gets covered. And you can see that. And then the next step removed is someone suing on behalf of an injured party, perhaps an estate for someone who's died or a parent for someone's child. And they can sue because of their relative close relationship with the person who's actually been injured with specific injuries. But these claims aren't alleging specific injuries that cause liabilities. They're talking generally about abatement costs, cleanup costs, you might call it, and there's no sort of specific injury being relied upon or evidenced. So it's a totally different type of claim.
Yeah, it's impact to the infrastructure, to the services, and the drain on the states, right?
Right. Yeah, and they're not referring it back to a specific injury. They're just saying, generally speaking, there's been all this problem.
So this is inevitably leading to coverage disputes, and we've seen many of those go before the courts already in the US with varying results.
Yeah, I think it's fair to say there's been a mixed bag in the US. And that's where all the jurisprudence is coming out. There isn't really any in England or in Europe or anywhere like that. So there's been a bunch of cases in the US at different states, different levels of court. And they've been a mixed bag in terms of whether on account of or because of personal injury is to be read broadly or not. I think the momentum is probably against a broad reading of that these policies are not, on account of language, is not designed to cover abatement expenses, not designed to cover public nuisance, not designed to cover people who are, many steps removed from the actual injury. And I think that's the momentum of it. But there are cases out there that say different. But it depends where you are. I mean, we've seen these policies, Bermuda form, you talked about earlier, Kent. The Bermuda form policies, typically modified New York law applying to them, and they are arbitrating in Bermuda or London or Canada or somewhere like that. None of these cases in the US really impact or not directly referable to those cases, I don't think. Then you have US liability policies that are maybe subject to a state law. They are probably much more dependent upon this jurisprudence coming out of the US. And then you might have London market policies or European policies that might have English law, and English law is way behind on decisions making, about on account of.
Well, I don't think any of the opioid coverage cases have come before a court in this country.
Right.
I mean, the decisions, few that there are, been in arbitrations. And that's likely to remain the case, I think, for some while. Although we have seen a number of cases in the US where, once again, as Purdue tried, and that is to embroil insurers in proceedings. We've seen it with Mallinckrodt in Missouri, for example. We've seen it in New Jersey with Rite Aid. And so, okay, to Mallinckrodt, it's creditor committees, again, that are looking to bring the insurers into the proceedings, irrespective of the fact that they may have English governing law provisions, English jurisdiction clauses, and so on. I mean, those attempts have been unsuccessful. It remains to be seen whether proceedings are ever commenced in the commercial court in the UK. We'll have to wait and see on that front.
In the case of Purdue, it's also an interesting phenomenon that at the beginning of the Purdue bankruptcy event, the filing of the Chapter 11 petition, the potential claimants were given 180 days to file their claims. And there were 615,000 of these claims that were posited with the court. The theoretical value of those claims was in the trillions of dollars. That having been said, the total assets available from the Purdue companies is arguably not more than $2 or $3 billion. So when you talk about allocating available monies to cases that are worth theoretically trillions of dollars, each claimant would get a dime or a nickel or a quarter or, enough money to buy a stick of gum or whatever the case may be. So the practical reality is that by the way, let me back up for just a moment. The 2001 insurance tower, as originally written, was approximately $950 million.
Yep.
That tower now has about $700 million of available insurance. So you're looking at, even if you add a couple $1 billion worth of Purdue assets to that $700 million in insurance, you're looking at a drop in the bucket. I also am aware of the fact that, notwithstanding the fact that the domestic insurer claim cases in the bankruptcy court are stayed at the moment, nevertheless, my understanding is that there may be a motion for summary judgment on the horizon where the domestic insurers basically seek to dispose of all the cases against them on the grounds of their products liability exclusions, basically saying public nuisance doesn't apply and we exclude products liability.
And if at that time they then come after the arbitration insurers, they face multiple could be facing multiple arbitrations.
Yeah, there are 16 insurers, 16 foreign insurers in the 2001 tower. So theoretically, if they wanted to go after those insurers, they'd have to institute 16 separate arbitrations, which probably would not happen. My guess is they would probably pick out a target defendant and see what probably one of the larger targets and see what happens. But that would take, the arbitration itself is going to take several years.
Yeah, I can see that happening. So what lessons are to be learnt from the experience to date? And looking to the future, what impact is the opioid coverage litigation likely to have, for example, on the PFAS claims that we're now seeing through the per and polyfluoroalkyl substances claims, the forever chemicals, microplastics, climate change, and so on? These public nuisance theories are going to impact that type of claim as well, I would have thought, for the insurance industry.
If I was going to hazard a guess what is either is developing or will develop, is tighter definitions of what is a product. For example, in the PFAS context, we're talking about molecules, but there's thousands of different molecules. Some years ago, there was litigation involving, and still is litigation involving Monsanto's PCBs. We learned that there are 209 different varieties of PCBs, only a handful of which are harmful to human beings. We know that there are thousands of PFAS chemicals, which are compound chemicals made up of various and sundry atoms, where some of those compounds may be harmful to human beings, and many of them are not harmful to human beings. The fact of the matter is, even if you read the studies that are out there now in the PFAS context, virtually every human being on planet Earth has boatloads of PFAS atoms in their bodies, yet the overwhelming majority of people have not been harmed. So that, and in fact, that is going to be one of the key areas of defense in the PFAS litigation, which is general and specific causation.
Yeah, I can see that.
Yeah, I think also for insurers, I mean, this is the way that things are going. So as you say, PFAS is very similar. Causes of action for abatement costs and things like cleanup costs, I described it earlier. Same for climate change, same for microplastics. Insurers are really going to have to take the bull by the horns a little bit, because it's all very well slapping on an exclusion for PFAS after the event, but that doesn't deal with the next crisis. So they may have to think about not directly changing the insuring clause, but doing little tweaks to the policy that make it clearer that what is designed to be covered is more immediate complainants that are, very directly associated with the actual injury being suffered.
That is already partly in the works. If you compare the XL003 form to the XL004 form, you'll see that the coverage on account of personal injury refers specifically in the 004 form to injury of a particular person.
An
individual, which solves that problem to a certain extent. I also think that there may come a time when the very idea of public nuisances is simply excluded.
Yes. That would seem to me to be the answer. Gentlemen, thank you very much for your contribution today. Very much appreciated. Thank you for listening. We hope you found it insightful, and thank you to our guests. Kent, thank you for making the trip over to London to join us today.
You're very welcome. Thank you.
Nathan, thank you for making the trip across London to join us today. Very much appreciated. And we hope you'll join us again for the next episode in the series.
Thank you for listening to Risk Matters, the DWF Insurance Podcast. We hope you join us again soon for future podcasts in our series.